Yes. See, now under contract of agency, till now we have discussed what do you mean by principal, what do you mean by agent, what are the rights of an agent, what are the duties of an agent. Now next thing comes is liabilities. Liabilities of an agent. See this topic, liabilities of an agent. So under that, first point is when the contract expressly provides. What do you mean by this? When the contract expressly provides, nothing but before itself, if it is stated in the agreement that whatever the acts done by the agent, then for that act agent is liable. In that case agent is held personally liable. That means in the normal case what happens, principal is liable, isn't it? Why? Because principal is the person who has appointed the agent. But if it is given in the clause of the contract that whatever the act undertaken by the agent for which agent itself is the personally liable, in that case agent is liable. So that is the meaning of this one. See this, if in a contract it is mentioned that agent is liable for the contract executed by his principal, an agent will be liable to the third parties for all the acts of the principal. So third party means any parties uh, leaving principal and agent. So A is a principal, B is a agent, so C is a third party, D is also a third party here, outsider to the contract. Here contract means contract of agency. So that is first one. Second one, when an agent acts for foreign principal. You know the concept of foreign enemy and alien enemy and alien friend. So here foreign principal means the principal who is not there in India, who resides in some other country, and agent is there in India and agent works for that principal who is there in some other country. In that case all the transaction, whatever the transaction happens, that occurs in India, isn't it? Why? Because agent is there in India. So of course in this case agent is liable to all the transaction or all the third parties. Why? Because agent is in India and transaction occurred in India on behalf of principal. Principal is not liable because principal is there in some other country. So that is second one. Now third one, if you see, when an agent acts for an undisclosed principal. So what do you mean by undisclosed principal? Undisclosure means here identity of the principal is not known. So for outsider, you are not disclosing who is your true owner or who is a principal, you are not saying, and agent itself is acting like a principal. That is the case here. So when agent acts like a principal, agent is liable for the third party because third party thinks that he itself is the true owner of the goods. So whenever we are dealing in the goods, we are talking about that is sale of goods, sale and purchase of goods. For example, so A is a principal, B is an agent. So but to the outsider, let us say C or D, B acts like A. In that case B is liable. So that is the meaning here. See this, agent is personally liable as the identity of the principal is not known to the third party. Now fourth one, when an agent acts for an incompetent principal. So what do you mean by incompetent? If a principal is a minor, first of all, if principal is a minor, in that case, of course, agent is appointed. Or principal is of unsound mind. Unsound mind again, there should be some stability, or there should be someone who is going to take a rational decision. For that purpose, agent is appointed. Or the principal is a person disqualified by law. In that case also what happens, agent is appointed. In all these circumstances agent is liable to the third party. Yes. And there is a case of lunatic also. Lunatic, you know, some for some duration he will be unstable and for some other duration he will be stable. So this is a case of lunacy or lunatic. Yes. So now fifth one. If you see the fifth one here, where an agent signs the contract in his own name. So can he sign the contract in his own name? That is the first question. Usually what happens? Principal has to sign all the contracts. See, but sometimes in the case of emergency, agent gets the right to sign the contract. All the contract with the third party should be signed by the principal only. Therefore, if an agent signs the contract in his own name without disclosing the fact, he is personally liable. What do you mean by without disclosing the fact? That is, he is not the principal. He should say he is not the principal. He is acting on behalf of some other person. If he doesn't disclose this fact, then agent is liable. So when we are discussing about rights, duties and liability, so now I clearly remember this question. If you see the past question paper, this question comes for 24 marks. What are agents' duties, rights and liabilities? Very frequently it is asked. So now sixth one, if you see, where an agent acts for principal not in existence. What do you mean by not in existence? Not in existence means unregistered principal. What do you mean by unregistered principal here? What do you mean by unregistered principal? Can you tell me? Unregistered principal. Suppose the company is not registered. In that case, what happens? Promoter. There is a concept of promoter. So promoters are the person who are there at the time of starting the company, and they will stay for some duration, or they may stay until the winding up of the company. They are known as promoters. So until the company is registered, they are treated as promoters of the company. As soon as the company gets registration, then they become principal. So that is the meaning of this one. See this, promoters of the company which is yet to be registered act as an agent for the company. In such case, the promoters are held to have connected or contracted, held to have contracted on their own account and are personally liable. That means you cannot treat the promoters as a principal. They should be treated as agent only when company is not registered. So that is the sixth point. Now, after that, seventh one, when where an agent receives or pays money by mistake or fraud. So this is very simple. Mistake and fraud, you know, it is avoidable. So in the case, suppose he receives money from someone else by mistake. In that case, of course, the agent has to return that money, isn't it? Why? Because he has received the money by some mistake. Yes. In the case of fraud also, in the case of fraud, he either he has done some fraud or other party has done some fraud. In that case also, there will be some legal proceeding. After that, money will be returned. So in that case, agent is liable. That is about seventh one. Next, where his authority is coupled with his interest. So what do you mean by authority coupled with his interest? In this case, what happens? Here, personal interest is combined with professional interest. In that case, if he brings his personal interest in the subject matter of the contract, in this case, what happens? He has a right to sue or can be sued. What do you mean by sue or can be sued? Either he can file a case against the third party, or third party can file a case against the agent. So that is the meaning of this one. So that is about point number 8. Now point number 9, if you see, where the trade usage or customs makes an agent personally liable. So trade usage or custom means if there is no rules and regulation, there will be some traditional way of doing things, isn't it? So it is one kind of rules. So if you see, when rules and regulation provide, in that case agent is liable. So that is about point number 9. So there are 9 points given for liabilities of an agent. If you see liabilities of an agent, there is 9 point. Then about duties of an agent, if you see, there are 13 points. And about rights of an agent, approximately there is 8 point. So 8 plus 13 plus 9. So how much it will be? Almost 30 point is there. So if you remember all the points, all the 30 points, so then it will be easy for you. You can write in your own words if you know the side points, if it comes for 24 mark question. So 24 mark question, you know, you have to write for 6 pages, isn't it? Minimum of 6 pages. They say not exceeding 6 pages. That means you have to write minimum of 6 pages. Yes, that is the meaning of that statement. And 12 marks, minimum of 4 pages. and for 6 mark minimum of 1.5 pages. Yes, if you write this, then of course your total number of pages will exceed 30 or 32, and that is more than sufficient. If you write 30 or 32 pages, then it is more than sufficient to score good marks in law. Yes, at the end of the day they won't see quality. Quantity is also very important, because valuation, you know how valuation happens. Within very short duration they have to correct many papers. So for that I am telling, so there is no time in seeing all the things. So that is about liabilities of an agent. So any doubt in this, you can ask me about liabilities. Any doubt? Any doubt in the liabilities of an agent, you can ask. Amrita, Ankita, Anusha, Ashish, Narasimha, Nishant, Omkar, Pratish, Shifali, Suresh. Yes. And one more thing I would like to tell you all is that, see, I have given you the assignment that is nothing but notes, and most of them are not submitting the notes. So I don't know why. What is the reason? I don't know. Even after giving sufficient time, you can at least, if you write one sum per day, then also you can easily complete the notes. So why you are unable to complete the notes? Because you are delaying the process, and you are taking everything and you are writing everything in a one day. So if you do like that, then of course it will be an additional burden for you. Instead of that, if you try to write one sum per day, then also you can easily finish that all the sums, whatever is there in the chapter. So I say that by 25th of this month, I want that third chapter note, that is valuation of shares notes, is needed, completed notes. So till now all 6 sums I have given for assignment. So in that chapter remaining sums are there, right? Valuation of share, that you need to write down in your notes and submit it by 25th of November. So by doing that, you will finish 3 chapters of notes. Why I am saying to write notes? Because it is one kind of practice, because we are not solving the problems. That is why notes is very very important. At least then you can understand something by writing. Okay, so that is why I am giving, and no other reason. Okay, so I hope everyone will submit the notes. So now let us see the next topic, last topic, that is termination of agency. So in termination of agency, first thing we need to know, what do you mean by termination? Termination is nothing but it's cancellation. When and all cancellation of agency happens, or when a contract of agency comes to an end, that we need to see. So there are few circumstances under which contract of agency comes to an end. First one, termination of agency by the acts of the party. So if parties in a contract of agency does some act, that means either principal or agent, agency, contract of agency comes to an end. So how that happens? See this. This could be done in any one of the following way. First one, agreement. So what do you mean by agreement? Under agreement, here both the party agrees to wind up the contract or cancel the contract. So in that case, mutual consent is required. In by that case, what happens? Principal agency comes to an end. Second one, revocation. Revocation by the principal means it is one kind of cancellation or taking back his right. So if principal takes back or principal withdraws from the contract of agency, in that case agent is automatically agent also automatically withdraw from contract of agency. See this, principal has a right to cancel his contract with agent in case the agent is negligent in performance of duty. If principal feels that agent is not performing well, or agent is not following the instructions given by him In that case, principal can cancel the contract. That is known as revocation or cancellation or taking back the rights. Now, third one, revocation by agent. So similarly, even agent can also do, isn't it? If agent feels like he can't continue in this contract, if a principal is not paying him properly, principal is not given the remuneration in time, in that case, agent can also cancel the contract. See this. If an agent is not willing to continue, he can cancel the contract of agency. Agent must give revocation notice to the principal. So in this case also notice is needed, revocation by principal. That is notice must be given to the agent. Revocation by agent, notice must be given to the principal. So this notice usually preferred date is within before 15 days. Before 15 days, at least you should inform the other party that you are not willing to continue in the contract of agency. So there are three circumstances for termination of agency by the acts of the party. First one by mutual consent, that is by agreement. You are deciding in advance, after this fixed duration you will cancel the contract. Second one is revocation, that is principal cancelling the contract. Third one is revocation by agent cancelling the contract. So now second one, if you see, termination of agency by the operation of law. So here operation of law means, here if you see, as per the court, as per the court's order, or as per the acts specified in Indian Contract Act. So now let us see. Sometimes law puts end to a contract of agency. Following are such cases. So one is usual mode of discharge of contract. We have discussed the discharge of contract. What do you mean by discharge of contract? Both the parties have performed their respective obligation. Suppose there are two parties A and B. A performed their whatever the duties he has to perform, and B also performed whatever the duties he has to perform. In that case, what happens? Automatically, contract comes to an end. So that is known as discharge of contract. Discharge of contract can be done by the usual mode, that is performance. Performance means what? Both the parties have performed their respective obligation. That is about first point. Second one, expiry of time. So what do you mean by expiry of time? Suppose the contract is formed for specific duration. Let us say the contract is formed for 1 month or 2 months. As soon as that specific duration is completed, contract comes to an end. So that is the meaning of expiry of time. Then third one, death or insanity. So you know, right, in a contract anyone dies, automatically contract comes to an end. Either principal dies or the agent dies. It automatically contracts comes to an end. In the case of insolvency, insolvency means here ability to pay is questioned. Either principal's ability to pay is questioned or the agent's ability to pay is questioned. So in that case, what happens? Again, contract of agency comes to an end. See this, insolvency of principal ends to a contract of agency, whereas insolvency of agent does not affect the contract of agency. That means even if the agent is insolvent, you can continue with the contract. You means here principal can continue with the contract. But in the case of principal has not paid any remuneration, or principal is withholding the payment due to the agent, in that case agent has every right to cancel the contract. Fifth one, destruction of subject matter. So what do you mean by destruction of subject matter? No subject matter is equal to no contract. If, let us take the example, very famous example is of cow. If cow itself is not there, then how you can perform the contract? Because suppose A and B enter into a contract to sell the cow is a subject matter in that case. If cow dies, then no contract. Very simple. Then sixth one, principal becoming an alien enemy. If war breaks out between the two countries, let us say principal is from some other country. Now he is a alien friend. Now he is alien friend. As soon as war breaks out, what happens? Principal becomes alien enemy. In that case, contract of agency is suspended or it is terminated. Next, seventh one, if you see liquidation of agency or liquidation of company. So what do you mean by liquidation? Liquidation is one kind of winding up. When the company is liquidated, contract of agency automatically comes to an end. So what happens when the company is liquidated? All the assets are realized and liabilities are paid off. So agency, whatever the claims of agent is there, that is also settled. Then last point comes is termination of sub-agent's authority. So what do you mean by sub-agent? If agent appointed some other agent to do his work, that person is known as sub-agent, and he can appoint sub-agent only with a prior permission from the principal. See this, termination of an agent's authority puts to an end to sub-agent's authority as well, provided agent has appointed the sub-agent with prior permission from the principal. So let us take the example. A is the principal, B is the agent, and B says with A that he will appoint C as his sub-agent. So and A also agrees. In that case, what happens now? A principal, B is the agent, C becomes sub-agent. Okay. Now A says you are B is terminated from the contract, or B is discharged of his duties. In that case, what happens? Automatically, C is also discharged from his duties. Why? Because B is a main agent, isn't it? C is working under B. So that is the meaning of this one. So all these things comes under termination of agency. So main 2 points under termination, one is termination by act and second one is termination by law. Under that several points are there. So if you see